Hello everyone, welcome to Legal Act. In today's video, we will learn about the amendment of the Constitution under Article 368. We will also look at various types of amendments, Supreme Court judgments related to the amendment, and how the concept of basic structure evolved through these judgments. Article 368 under Part 20 of the Constitution of India deals with the powers of Parliament to amend the Constitution and its procedure. There are three ways in which Constitution can be amended, but Article 368 provides for only two types of amendments, by special majority and by special majority along with ratification by half of the states. The third way of amendment is by simple majority. First, by simple majority, it means majority of the members of each house present and voting. Second, by special majority. It means majority of the total membership of each house and a majority of 2/3 of the members of each house present and voting. Third, by special majority and ratification by states. This means special majority and then consent of half of the state legislatures by simple majority. Now, the most important question regarding the amendment is, can fundamental rights be amended? But before answering this question, let's first understand the concept of basic structure and how it evolved through the judgments of the Supreme Court. Shankari Prasad case 1951. In this case, first constitutional amendment was challenged, which amended the fundamental rights guaranteed under Part 3 of the Constitution. The argument against the validity of this amendment was that Article 13 prohibits state to make any law which takes away or abridges the fundamental rights. However, the Supreme Court upheld the validity of the First Amendment. It was concluded that the word law in Article 13 Clause 2 is for ordinary laws and not constitutional laws. The Supreme Court held that the Parliament had exclusive power under Article 368 to amend the Constitution, including the fundamental rights under Part 3 of the Constitution. Golaknath case 1967. In this case, the Supreme Court overruled its previous judgment in Shankari Prasad case and held that the word law in Article 13 Clause 2 also includes Constitutional Amendment Act, and therefore any amendment violating the fundamental rights would be declared void. As a reaction to this decision of the Supreme Court, the Parliament in 1971 enacted the 24th Amendment Act. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. Keshwananda Bharti case 1973. In this case, the Supreme Court overruled its judgment in the Golaknath case and upheld the validity of the 24th Amendment Act. The Supreme Court held that the Parliament has the right to amend the Constitution, but it shall not change the basic structure of the Indian Constitution. So now, to answer the question, can fundamental rights be amended? Yes, fundamental rights can be amended, but without any interference with the basic structure of the Constitution.